All right, everybody, welcome to the Creative Finance Collective. It is 2 p.m. Arizona time, and we're going to talk about creative financing. We have with us, and we're bringing them on, Scott Horne, Sean St. Clair, Alan Seshker. Can everybody hear me? You guys all there?
Yep.
All right. Well,
Yeah, we
if
can hear
you
you.
are just if you're just joining us, so a couple rules of the game. We're talking about creative finance and the laws with respect thereto. And if you have questions, we're here as long as we're getting questions. So it is important for you, the listener, to post those, and we will get to those as they come up and talk about whatever else we decide to go through. Alan and Scott, how's Texas? We haven't talked to you guys in a couple of weeks. What's going on over there?
It's just menagerie as usual.
Oh, as
And I found
usual.
it interesting if you're opening that it's about the laws that govern. Do people actually think about laws that govern and follow them?
Well, that's the
No.
hope. That's the
That's the
hope.
hope.
Yeah,
Thank goodness.
I don't know. Is Alan, is Texas as boring as Scott makes it sound?
This is me with the dog here, but
Well, just when we were talking about how boring Texas is, it sounds pretty exciting.
all right, I think we got it covered.
Oh, we got it. All right.
It's fantastically. I don't want to call it slow, but I think everyone's hunkered down and waiting for some kind of something somewhere. Don't know if it's an election. Don't know if it's interest rates down. Don't know if it's the geopolitical stuff. Don't know, but someone's pumped the brakes pretty darn hard on the conventional stuff. Investor stuff is still good because there's motivated and distressed sellers out there, and some investors who were smart and kept some money on the sidelines. So it's a weird market again.
No, I think, and just to echo that, Alan, I agree completely in that you see the retail side is really slow right now. Deals were flying off the shelf in 2 to 3 weeks. Recently, not 1 or 2 days, but they in the right neighborhoods they would sell quickly. But that time frame is now minimum 90 days up to 6 months, which is to me getting back to normalization timeframes for selling of properties. But even on the seller finance side of the equation,
Yeah.
at least on the owner occupied wraparound type transactions, that has slowed down and that time frame has exacerbated in the marketing. The acquisition stuff is still out there for the rental marketplace and those kind of items as they come up. But with Alan, I mean, you asked the question, what is it? Is it interest rates? Is it the election? Is it the economy? I mean, is it the economy stupid, as they used to say? I think it's all of those. I think people are timid. I think they're spooked a little bit. I call this economy kind of spooky because I got no clue which way it's going to go. We hear all these rumors of it's going to implode on itself and this and that's going to happen. You get inflation rates. You can't trust the government numbers on employment. And is there really employment out there? Is there not employment out there? What does that look like? And I think all of that in this big ball uh, affects people's decisions.
Well, I think all of that's all correct. The one thing I think we all know is the market hates uncertainty, and what you just explained is a whole lot of uncertainty. You can go online. It's really interesting in different minds that I usually follow and kind of respect. And in one post, you'll get doom and gloom. The recession is tomorrow. And in another post, or not just a post, another news update, the S&P 500 is hitting another all-time high, and a significant, kind of bull run that's been going on some time. And then you hear about inflation, but then the Fed's cutting and the election, just like what you said, the market doesn't like uncertainty, and it's waiting for some of that.
Well, you'll notice that when the Fed cut the rates a few months ago by a half point, everybody was thinking that that was going to cause this jump start, and it didn't.
No.
And I know that there's an anticipation to do it again in November, but does the average person really hold off watching the Fed and watching those kind of things? I don't think so. And I think you talk stock market, and you talk real estate, we're talking apples and breadfruit or something
Yeah.
like that. It's not even it's as far as the east is from the west, I think sometimes.
Well, and if you're waiting for interest rates to change, I was reading an article about this when interest rates started to go up, when they started that process, and the reality was, because that started in mid 2022, maybe early 22. I don't remember, but the reality when they cut or raise by that amount, it takes almost a good year for the economy to absorb that and start feeling the effects of what that looks like. And then over time, as they're doing it slowly, it takes time. So things don't, yes, we might be in a cutting cycle and money might be starting to get cheaper. Uh, but that's probably not going to fix inflation. It almost certainly won't. And by the time the time it takes for the economy to start feeling those cuts isn't going to happen overnight. And the dirty little secret probably is, inflation and interest rates and what the Fed does probably doesn't have a whole heck of a lot to do with in the long term with the election, but that adds its own little bit of uncertainty. So we'll see. If you're joining us, we got a few more people that have joined us since we started. This is the Creative Finance Collective. We do intend to talk about creative finance, although macroeconomics and interest rates has everything to do with creative finance and why it's important in the market. If you're joining us, though, we are taking questions. So post those in the chat. We want to get to them, and we'll be on as long as we're getting those questions. While we wait for questions, guys, Sean and I were talking about a couple other things that we wanted to get your take on. One of them was, I think, a federal regulatory one. Sean, did you want to explain that?
Yeah, so you guys are probably up to speed on the new FinCEN rulemaking that is going to require title companies all the way down to attorneys who basically convey property to LLCs when the transaction doesn't involve a federally insured loan, where now you have to do the same FinCEN reporting that you did basically under the CTA, the beneficial ownership information. You guys are, I'm assuming, aware of it. How do you think that's going to impact closings, the cost of closings, all that good stuff? Time frames for closings.
Which regulation are you talking about?
So at the end of August, FinCEN passed a rule which basically said that if an LLC purchases a property in cash or with hard money and they're not obtaining a federally backed loan for the purchase, that the title company, similar to the reporting that has to be done under the CTA, has to gather the beneficial ownership information of the LLC owners as well as the seller in the transaction, socials and dates of birth and addresses and the whole thing. And they have to go to the FinCEN website and they have to plug in the property information and all this personal information regarding the parties to the transaction and the their information and whatever, and plug that in as part of the closing process. And it's the duties on the title company. And then as to attorneys, if say I prepare a deed conveying rental property from their individual name to their LLC, I then have to gather all that information and report it as part of this new rule. So it's basically the CTA, but for real estate. Exceptions are if the LLC is obtaining, or in that same transaction, if they're obtaining federally insured financing, because of course the lender is going to report all this information. And publicly traded corporations, so your Wall Street firms, are accepted. They no reporting for them. So they can buy in cash all day long and nothing has to be reported. It's a rule, it's not a law, but that's what the rule is. And my understanding, you guys also may be aware of this, Scott in particular, since you kind of work nationwide, there's certain counties and states that already have this in place. And now instead of limiting it to Miami or LA or wherever, San Francisco, Las Vegas, they're expanding this across the country. And now nationwide, this reporting has to be done starting December of 2025 for any closing that meets that criteria. I attended a CLE where the title company, in-house counsel for the title company, said they're going to probably charge $200 to $400 more per transaction for those particular transactions because of the additional time involved in having to process that transaction. So just kind of getting your thoughts on it, since you guys do, closing work, and if you guys were up to speed on it and what your thoughts are.
Well, one, I was not up to speed, so thank you.
Yeah.
Today was worthwhile coming here. Awesome. Next, you always hope that those kind of things get overturned, just like we're hoping the CTA gets overturned before year end. But it probably won't. It may get, overturned next year based on things that may or may not happen. But I'm with, your course, administrator there for that title company that, it takes time to compile all of that.
Mm-hmm.
You should have most of that information, but you still got to go onto the site. You can't forget about it. You got to upload it. And it takes somebody, I don't know how long yet, 15 minutes, 30 minutes to do all that and get it done.
Yeah, the Land Title Association estimates that it's an extra 2 hours.
Per file?
Yeah, that's what they said.
I don't know if I buy that. I mean, I haven't tried it, so I can't tell you, but entering basic information on a seller and on a buyer into a site that you're accustomed to doing shouldn't take 2 hours to do.
Yeah, but you also are having to gather information that maybe you otherwise want to gather, like social security numbers.
I think you just automatically update your information sheets that you send out to everybody. In our title world, we send out seller buyer information sheets that has all that information on there. And now you may take those sheets and add to that, this additional information that is required to be reported. So you're going to have to gather 2 or 3 or 4 more pieces of information, maybe. So It's not going to be that big of a deal. It's just making sure you get it and making sure that you do it.
Right. Well, now they've increased, because now you're getting socials and dates of birth. You probably have a heightened document storage and protection situation under the GLBA as well. So now have a heightened standard if you're holding on to social security numbers and stuff.
Yeah, you got all that usually uploaded electronically. That's protected as well as you can. And of course, your hard files get into locked scenarios, so they're protected. But if you're not doing that, you've got to do it.
Yeah.
So this is just one more reason we should all vote libertarian and get the dadgum government out of our back pockets, right?
Well, I kind of thought what was interesting about this, I was just having a conversation with somebody in another state. It was about politics, and we were talking about agency actions and things like that. A lot of real estate, most of it is really, going to be impacted by laws at the local level, administrative rules and laws passed by the state at the local level. But what's interesting about this is, correct me if I'm wrong, Sean, but you said FinCEN. That's a federal that's a federal agency.
Correct. Yeah.
Agencies, if for the non-lawyers out there, when Sean uses the term rulemaking, that falls under the executive branch of the federal government. That is a branch of the government that the president of the United States controls. Rulemaking is not laws passed by Congress, signed by the president of the United States, so on and so forth. It is rules by administrative agencies. This would be an example where real estate is impacted by federal rulemaking, and where, honestly, to Scott's point, where your vote could potentially, you would have to have whoever the president is to want to deal with the bloat of administrative agencies and the things that they're requiring and doing. But it's kind of interesting. We have a federal election, and this is one example where real estate is directly impacted by rule makers.
Yeah, and in theory, whoever is elected to the executive office could go and basically, by a stroke of a pen, say, yeah, rule off, we're not doing this, and eliminate the rule if they wanted to.
Yeah. Alan, had you heard about that rule yet? This rule yet?
Now we've been dealing with county by county. We'll receive an underwriter bulletin that says, hey, in this county, do the FinCEN reporting in these scenarios. But I didn't know about the August one that made it permanent. You said December 25.
Yeah, so we still have over a year before it becomes permanent. Hopefully, giving some type of public interest or other group the ability to have a court challenge. I think under that recent case that really eliminated or significantly limited the Chevron doctrine, for federal agencies, basically stripped them of significant power. I think it might even be unconstitutional at this point, but we'll see.
Yeah, but someone still has got to pull that trigger. So either,
Yep.
The president has to, sign the document, or someone's got to pull that trigger in a court case, make that go away.
Yeah.
Sean, Andy, y'all want to volunteer?
Oh, if I was elected president, I shouldn't say this publicly. Not that I'm going to run, although my kids long ago, they thought it was such an obvious thing that why wouldn't you go run for president? They kept wondering why I hadn't. Like, it's great. You go live in this giant house and you get to do all this stuff. Why wouldn't you run for president? They just thought it was just the obvious thing to do. But if I ever was, man, the administrative agencies would be the first place that I would probably just go lay waste on all of it. I mean, what's really an interesting legal discussion, I think, is really the overall constitutionality of Congress essentially delegating most of its authority and wisdom to administrative agency bureaucrats that aren't elected and sit there and rule make, and it sounds nice in theory. And then all of a sudden, decades and decades later, you have a machine of rule makers that are basically answerable to nobody but the president, because it's an executive branch. But it'd be nice to see them put in check in some way, and have Congress take the responsibility of doing what they're supposed to do, which is pass laws and deal with the lawmaking of the country. But that would force them to pass little tiny baby laws to deal with little things in little situations, rather than enormous omnibus bills, where they can just vote on it without ever looking at it. But I digress. All right. So if you're just now joining us, we are talking about creative financing and anything else that we feel like. So if you've got questions,
politics.
Yeah. Well,
that sounded like, at least.
Yeah, well,
tis the season.
There is, yes, there is creative financing, and then there's political digressions, and I can wind them together. I think creative financing probably is connected in some way. But
Andy, real quick, that being here in Arizona, and this morning I've got it on the news listening, and you get the same commercials, you get the same stuff, just a different person from Texas to Arizona, from a standpoint of all the rhetoric you hear out there, and it's like it just follows you everywhere. Yeah. I'm sure it's the same in Wisconsin.
Yeah,
a little more cheesy, probably.
No pun intended. All right. Yeah, make sure to post those questions in the chat. We'll get to those. Sean, we were talking about another kind of factual issue with dealing with a due on sale clause, which I thought was interesting. Why don't you explain that?
Yeah, so there's a property that two borrowers, husband and wife, took out a loan. They conveyed it to their trust. Everything's cool. the two borrowers died, and the trust provided that 50% of the interest goes to my client, an adult, and then the remaining 50% goes to minors. And so with a testamentary trust. So 50% was distributed out to my client by deed of distribution. Once again, my client's allowed to own it under Garn St. Germain as an heir. The remaining amount stayed into the trust for the benefit of the minors. My client then takes the property, conveys it into her family trust with her and her husband. And the bank comes out of the woodwork and is like, you can't, what are you doing? Why are you putting it into the trust? We need all this information and blah, 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 blah. So I get involved. I respond to the bank, say, okay, borrowers put it in their trust, allowed by Garn St. Germain, goes from, the trust to my client as the heir, as allowed by Garn St. Germain, and then my client conveys it to her family trust for which she's a beneficiary. And I said, this falls within the spirit and purpose of Garn St. Germain to allow for estate planning. Shouldn't be any issues. And the bank comes back and they say, nope, because your client wasn't the actual borrower. Garn St. Germain only applies to the borrower's trust, and therefore they're not allowed to. You need to put it back into her name, which fine, we'll do that. And you know what we'll do? We'll record a beneficiary deed to the trust. It'll be all fine. Same result. Nobody cares. And we can do that. But I just thought it was somewhat kind of silly or tacky of the bank to make us jump through those hoops when the result's going to be the same and it really doesn't impact them at all. But in any event, I thought that was an interesting due on sale scenario.
I had never thought about that.
So I have a question on that. And I think we talked about it a few weeks back, but what's the motivation for the bank to come and mess with a loan that's performing?
I have no clue. It's a smaller bank, services their own paper, and it's federally insured, it's still federally backed, but it's just they service their own paper. And I have no clue why they care, because it really, to me, it doesn't matter. It's like, who cares? It went into her family trust. Now her husband's a trustee, but it doesn't matter. In fact, if anything, now you have another party that's going to pay the mortgage, right? So I don't know. I don't know what the motivation is other than to be just difficult.
Well, you can't use common sense. You know that, right?
Right.
Yeah. They don't want to, I hear that. I don't get it. And, I go back to my very, very first, I've closed a gazillion of these deals, whatever that number is. And I've dealt with due on sale maybe a total of 12 or 13 times total. So it doesn't really happen often. We all know that. In fact, my very first one back in 2010 on a property that I had owned personally I bought it inside of my one of my limited partnerships 15 years before. And I just transferred it to my family limited partnership, so everything was still the same ownership along the way, just different. And again, what was going on in 2010, the real estate crash hit, everything was blowing up. The mortgage companies had hundreds and hundreds and hundreds of thousands of defaults out there, short sale city, things like that. And I get a due on sale clause. And I felt so sorry for this poor young lawyer who I had to talk to at this foreclosure firm, or this firm that represented the lender. And I think I almost forced her into tears. It's just like, what are you doing? And I was so mad. I almost called my senator and went, what are y'all doing about this? This is stupid.
Right.
You have hundreds of thousands of defaults, and here's a fully performing loan. We're at like 30% loan to value. Really? And there is no logical answer for it. I don't think there ever will be, other than the fact that, Sean, maybe, as you said, you had a small bank service their own paper, kind of like a small credit union might do. And they're so hypersensitive on things, and they don't understand the basics.
Yeah.
You know, multiple players, multiple sources of repayment, not a single issue or problem. What's the problem? You're still in first
Right.
lien position. Nothing's changed. Why?
Right.
And
Yeah.
by the way, I'll bet you 100 to 1, they cannot give you an answer to that.
No,
Because
and that's just it. And frankly, I do think that if push came to shove, I think a court might look at it and say, hey, look, the whole purpose of Garn St. Germain was to allow those who are rightfully entitled to estate plan, to plan their estate. And that's all they were doing. This is why we have the Garn St. Germain. No, you can't declare the due on sale. I think we could maybe want it, but at what cost, right? When for a small fee, I can move it back and then do a beneficiary deed and the result's the same. It still ends up with the trust via, the recording a death certificate if ever gets to that. So it's pretty basic fix and not very expensive. So, do you want to spend a bunch of attorney's fees fighting it? But I think at the end of the day, we could have probably. I think the spirit of Garn St. Germain, is to allow for that because she's rightfully entitled. They don't dispute that. It's just saying, well, since she wasn't the borrower, she can't put it in. She can't estate plan. She has to stay on title in her name and can't put it into her family trust.
Well, the biggest issue there, Sean, is standing on principle, as you know, can be a very expensive prospect.
Yes.
And although you might win it in the day, you probably recover nothing. And do you really want to do that just to say you won?
Exactly. When we can do the same result for, little cost.
Yeah.
So.
Oh, I know it's frustrating.
Yeah. To that point, we did get a question on YouTube. Do you think the bank had a legal leg to stand on if your client wanted to not comply? So speaking to what you guys just said, the economics of it are if you can find a way around it, you don't go fight with a bank. I do think that it seems to me that there are legal problems for the bank in that situation. I think kind of the point you made earlier, Sean, was, or just a minute ago. I mean, if that's the rule, then as a practical matter, if you inherit real estate, you can't do estate planning. I mean, basically that's what that would mean.
Yeah, that's what they're saying.
I think that's silly. I also think it would seem to me that under, on a typical contract, deed of trust, promissory note, whatever the case may be, is going to have a successor and assigns clause, which references successors. I just don't know why that they wouldn't be given those same benefits or inherit those same benefits by virtue of maybe like a successor or assigns clause or something to that effect. But I think the bank probably has shaky legal ground. But the problem is, at the end of the day, you weren't talking to a lawyer, right?
No. And one of the things the bank said is basically like, hey, but if your clients want to, client wants to formally assume the loan or obtain another loan from us to refinance, we could do it that way. And I was like, no, I know how that's going to go. We're going to refinance at 7% interest or whatever.
Well, give the bank, at least, kudos for asking that question to their benefit, of course, right?
Yeah.
Right. Yeah.
No. It's amazing what they all try to do. And they're just, when one of you guys figure this out, please let me know. I need a crystal ball that works better.
Well, what's a little annoying about that question is, for the purposes of the question at hand, they're treating your client as some third party that's just looking to assume the loan, that has no rights whatsoever.
Right.
But would in another call recognize the fact that they have to recognize the ownership of that person, right? That they can't just call the loan due because they've suddenly inherited it. So, so it's not the same thing. It's a different thing, something you have to they have to recognize. That's frustrating.
Mm-hmm.
That really is. If you're just now joining us, we're taking questions about creative financing. Make sure to post them. And we'll be on here as long as we're getting questions. While we wait to see if we get any other questions, guys, you guys seeing anything else out there? Any interesting legal issues? Alan, I know for a while you were running into due on sale clause after due on sale clause issue. Is that slowed down, or is that you still seeing issues?
It's still an issue. Had one last week come in. The usual, hey, we see something wrong, possibly, please confirm that our borrower is the owner. And then we start jumping through some hoops. And I've asked everyone that I can, what do you care? But can't get an answer. I don't know if the banks have told the loan servicing companies, hey, check for this stuff, and therefore the loan servicing company has to do it. But the loan servicing company doesn't want to lose units,
Yeah.
and the bank, in theory, doesn't want to lose a performing note. So I just remain at a complete utter loss.
The only thing I can think of, because I want you all to think about this. Think up where do the great majority of loans wind up? Put into these huge tranches out in Wall
Yes.
Street somewhere?
Securitized. Yeah.
Yeah. Okay. Sold worldwide, probably,
Mhm.
whomever. And I was having this conversation with somebody literally, I think yesterday. And knowing that that's the great majority of loans where they go. And I get the small bank Sean was talking about. I get the small credit union where they service their own stuff internally and whatnot. And those are rarities, and it's just watch out for those when you come across them. But these huge investment funds that have bought these pools of mortgages, they care about one thing, getting their money, right? That is it. Don't tell me they want to take a house back and resell it so they can lend the money back out at a higher rate. They don't do that. They distribute that money. So that's not one of the reasons why. You hear this rhetoric on the street, oh, banks are going to foreclose on properties so they can lend the money back out at higher rates. Maybe you're a really small credit union or you're a really small bank. Someone might think that way. These big funds, they don't think that way. That is just not what they do, in my opinion. And as Sean said, the servicer who's servicing that huge fund, they want to keep servicing that fund. And it's easier to service a performing loan than a non-performing loan and not deal with all the negative issues there. They just want their money. And you just go, what's the problem? Why? And I don't see that being an issue, but it can be.
Yeah. So to your point, Scott, in Wisconsin, we have very few mortgage brokers. They're all community banks. If you're going to get a loan, you go to your local community bank, especially outside of the two big cities, Madison, Milwaukee. But when you're outside those cities, if you want a house loan, you go to, there's 3 or 4 generally community banks or credit unions. You go there, they make the loan and they hold the paper. They monitor their portfolio. The nice thing is they're more flexible. You can actually call somebody up and talk to them and, speak with to a decision maker. But because of that, subject to is not a huge thing up here for 2 reasons. Number one, those small community banks generally are relationship based with their borrowers, who generally also have, their accounts with these banks and relationships with the banks. So the borrower is feeling like, I feel like I'm doing something adverse to this, bank that I have a relationship with, and I don't want to do that. And that's number one. And number two, these community banks monitor their portfolio, and they will re-lend the money at a higher percentage rate. So if they have a low interest rate loan and they see that there's been a sale, they're wanting to call the loan due so that they can get that money back in the door, re-lend it at the higher interest rate. Versus Arizona, to your point, I don't know of any real community banks that lend like that. I mean, it's all mortgage brokers. They're all over the place. Like, it's a huge, business, and there's tons of them, and they're all securitized loans. And frankly, nobody knows anything about their lender. They don't care, I shouldn't say they don't care, but it's like, there's no relationship there. And then, to your point, you have these big securitized portfolios that aren't going to re-lend the money. And then the servicer's losing money because it's one less performing loan that they're taking a very small piece of. So I think geographically, whether or not subject to works, people are willing to do it. I think that has a huge impact.
And up there in Wisconsin, first off, if you guys would get more people than cows, you might change your ways a little bit up yonder, but I don't know. And I get the community bank concept, but there's a way to skin that cat too if you needed to. It just wouldn't be as attractive as it can be in a Arizona marketplace or a Texas marketplace per se. And and you're right, but these big funds, they have no plan to do this. I don't know why these servicers are in some cases calling these loans due or trying to, unless there is some contractual obligation where they have to do that in some regard. That could be an issue. Doesn't make any sense, but I
Well,
get it.
yeah, and so, Alan, just to follow back up with what you're saying, did you get any sense with the ones you're dealing with that there was a disproportionate amount of ones that happen to be community banks, or could you tell one way or the other?
Well, the big ones, home loan serve. So I would say out of the 8 to 12 that we've had, 50% is home loan serve.
Really?
Yeah, and then one fella called him up and said, what's going on? Why are you doing this? And he actually got an answer and said they were looking at their prior files that were in foreclosure that were then reinstated, and they're checking to make sure that their borrower is still the vested owner. Now, I don't know if that's true or not. It's just what they said.
So they're using the event of reinstatement as a trigger to basically be like, okay, let's look deeper into this
Yeah.
post reinstatement.
They should be damn happy they got their money, got the loan reinstated, and it's performing, but I don't get that reasoning still.
I mean, it has to be at the investor level, telling the servicer, all right, same as checking off a box that insurance exists. We want you to check off a box that our borrower is still the owner of the property. I don't know why they would do that from the investor level, but that's all I can assume right now until I'm proven wrong.
Well, what's interesting about that, if you're an investor that's buying subto, I mean, I don't know how many, if that's enough cases to set a trend or whatever else. It certainly has been in your office, something that you've taken notice of. But if you're an investor and you're looking at distressed properties, which is pretty common, right? That's where you can get good deals, reinstate it, come in. Those might have a higher probability of getting called or noticed, I guess you would say.
For home loan serve, yes. I think the other offending factor is just people not handling the transaction correctly, not getting insurance in place, having inappropriate contact with the mortgage company, borrowers calling, asking if this is okay to do, stuff like that.
You know what we need is, does anybody know like lenders counsel, somebody who works high level for some of these stuff? I'd love to have them come on and have a discussion. It'd be a great interview. I'm not sure they'd be willing to.
No,
but
they would have to argue just absurd positions like they did down at the legislature whenever the big bank lobbyists said, well, it's going to affect our ability to recover our collateral in the event of default.
Yeah.
I said, well, don't you just foreclose against a property, not an individual? And they just fluttered away.
Well, yeah, and I would suspect there was a lot of that, but it would be interesting to have the discussion, because it just leaves you thinking, like Scott mentioned earlier, maybe there's something in their agreements with servicers, or maybe there's something we just haven't seen and we don't know about that makes it a problematic thing. But beyond just the reality that we see, I don't know. That'd be a fun interview. I bet we couldn't get him to come on though.
Yeah.
And
I'm willing to learn. I'm willing to learn. Teach me.
Yeah.
If you got problems, if you got pain points, let's talk about them and see if we can get rid of them. And that way we're, end up with a alleged win-win.
Yeah.
I think we are, first off, such of a small fish in a big pond. They don't want to waste your time on that. I remember being at one of the Texas advanced real estate state bar seminars, and I'm in front of the 7-panel expert. And I'm asking a question about Dodd-Frank and some foreclosures and whatnot, just as an example. And it was complete deer in the headlights. Not one person, who were all the top experts supposedly, had a clue what I was talking about. And little Scott here is going, okay. And, you can go, like, for instance, University of Texas has an advanced mortgage lending CLE class in Austin every September, which is pretty good for our industry to get some new tips and whatnot. And I've had a chance to talk to a few of the lawyers there who are lender counsel. But these are, again, they're usually they're counsel for the bank, the mortgage company, not for the servicer. I have yet to find that lawyer for the servicer out there who can probably give us that answer. And I don't know how to get into them per se, but that would be an interesting phone call to make and see if they'd be willing to have that conversation.
Yeah.
Well, I told you my efforts with, I believe it was the attorney representing in a home loan serve one. And I asked the fellow, I said, hey, we're going to get it all cleaned up and, what have you, deed it back over to the borrower. But let me ask you a question. Why does your client care? And I told you all this. He said, well, because it's a breach of the deed of trust. I said, I know, but from a business standpoint, why does your guy care? He's like, well, it violates the deed of trust and the due on sale clause. I asked a third time, he parroted the exact same thing back, and I said, I don't think you understand what I'm trying to do. I think me and you need to go get a scotch and sit down and just talk about this like a law school type question. And he goes, I don't drink scotch, and I was done.
Well, Alan, you can take me instead, okay?
I will.
Yeah.
But, the reason you got nowhere with that is you're not dealing with the servicer's counsel. You're dealing with the foreclosure firm that was the hired gun to handle the foreclosure, a line barger, for instance, or somebody like that along the way. And, a Barrett Daffin, whatever it might be. Those are the guys you were talking to, and they're there to collect a fee and charge as much as humanly possible to their lender because they know they're going to get paid for every penny of that.
Well, now that I think about it, that fellow didn't know.
Yeah.
And he didn't want to sit there and try to opine, okay, here's probably what their reason is or what have you. And so I'll wait for the next one and try to ask them.
No, and I'll just share one last little story too. Having been into a mediation with Bank of America many, many, many years ago, you're supposed to be there to solve a problem and take care of it, right? And you're supposed to have a decision maker there. Well, of course, the person they send can't make a decision, and they have to call their boss. Well, that person couldn't make a decision. It had to go up 3 different levels to try to find someone to make a decision, and then they couldn't make a decision because it's not their money, and they don't care.
Yeah.
For the small guys in the marketplace that are who we all deal with typically and represent, we all care because it's your money, it's your cash flow, it's your livelihood, it's your business, whatever it might be. You get up into these big servicers, into these big banks and whatnot, the too big to fail guys and those kind of items. My philosophy is they simply don't care because it's not their money and they have no liability. They're just going to follow whatever they're told to do, read the script, and go. And that's a shame. And I don't know how far up that rung you have to go to get that answer, or if you could ever get that answer.
That's a pretty long way up.
Yeah. That's what stinks.
Yeah. Oh, well, really good information, good discussion. We've gotten all the questions that we've had so far, so I don't want to take up any more of your guys' time. You were kind enough to be on here with us. We only solved about half the world's problems, but maybe after another episode, we'll have the rest solved.
Well, this is a pretty good place that we can solve them, because I'm sure all of our answers are correct.
Yeah. I'm still holding out hope we could get a lender's council. That would be an awesome discussion.
I've got to ask y'all another question though, because next you hold these on Tuesday, and Tuesday is the 5th of November. I think is an important day. It's also foreclosure day in Texas. And I know I've got to be running around, I don't know where, on that day too. But are you still going to have this in the afternoon?
Oh, I thought you were going to ask if you wanted us to do a collective live stream of the election results.
Well, we could go out to the polling, places and hold live feed possibly.
I think there could be an audience for live streaming to get Scott's reaction to the election.
As the results come in.
Yeah.
You don't know how high my soapboxes can go,
Oh man,
and
that
my tolerance would be very low, I think.
the problem with that in theory is if we could guarantee an answer to the election by, let's say, 9-10 p.m., I'd say, all right, let's do it. But we might have to commit to like a week long live stream before we get the results. You know what I mean? If it's anything like the last time around.
It'd be the Jerry Lewis telethon, old school.
Yeah.
Are
Oh
you going
man.
to play Jerry?
Oh, I can be Jerry easily.
Okay.
I think of all the people that watch us on YouTube, maybe 1% of them even know. I wonder if there's
Jerry
very
Lewis
many.
is?
Yeah, who Jerry Lewis is. Yeah.
They don't, yeah.
No,
Or
I'm
Dean
sitting there.
Martin.
I'm sitting there with my dang employees, and I go, "Hold on. Who's on first here?" And everyone's looking at me like I just babbled something in Greek.
Yeah. Why is this guy talking about baseball? He's lost his mind.
Who's on first?
Yeah,
Wow.
we have the same thing. I'll ask about a movie here in the office, and I'm not asking about a movie very far back. Like, let me like A Few Good Men from the '90s. A Tom Cruise movie. This is not that far back, and they're all like, "What?" And I'm like, "Wait a minute, you haven't seen this, or you pick your movie." But yeah, it's a whole nother generation.
You can't handle the truth.
You can't handle it.
Oh, thank you. But that is so true. There's some of the old classics that, well, for some of us older guys, when you go back to the Caddyshacks or the Young Frankenstein, some of the movies that were pretty funny and whatnot,
Yeah.
and they ain't got a clue.
Young Frankenstein, that's Gene Wilder, right?
Yep.
Yeah, that was
Or
a
you
good
see a
one.
Blazing Saddles, which would be just totally barred, in its uncut version today.
It won't work today. No, sir.
No.
And things like that. And it's like, what is wrong with the world that they just lose sight of all those kinds of things?
Yeah, in fact, just saying Blazing Saddles probably just got the collective demonetized. Thanks, Scott.
Maybe we should all just retire from life. We'll go up to Wisconsin and go ice fishing with John.
Yeah, that sounds good. That sounds good. All right, guys. Well, it's been a good one. Thanks for your time. We'll see you next time.
Adios, boys.